Hello and welcome. I am joined by my colleague, Sarah Kacharski, one of our Park Memorial Aftercare specialists, and Megan Coper, Wills and Estates lawyer with Will Wise. My name is Christy Hammond, and I am Public Relations Coordinator for Park Memorial Funeral Home. It's my privilege to welcome you to our third in the series of Wills, Estates, and Final Wishes. Our goal with these events is primarily to educate and give factual information without judgment that will make decision-making easier. Our hope is that we inspire you to take action in a way that is meaningful and intentional for your family and your loved ones. The subject for this session is probate, and we know how scary that word often is to hear and to think about. Our conversation will definitely educate. It will challenge some misconceptions, as it did mine, and will hopefully take the scariness out of the concept of probate for each of us. Before we get into the meat and potatoes of our discussion, Megan has an important message to share.
Hello, everyone. As with our previous sessions, our discussion today is for informational purposes and should not be considered legal advice. Answers to your questions can vary significantly based on individual circumstances, and new information may lead to different conclusions. Please seek appropriate legal advice before acting or not acting on any of the information we provide today. Also, some of the specific rules we'll be discussing are based on Alberta law, and these may vary outside of Alberta.
So here's a situation to get us started. Marie's mom passed away a couple of weeks ago. The family has held their funeral and celebrated Mom's life, and now it's time to look after Mom's estate. Marie is the executor, and she knows that Mom had some solid investments that did well in the last couple of years. Mom also owns a condo and it's in only her name. And she also has a couple of bank accounts at two different banks. Marie has been dreading this process of caring for Mom's estate as she knows that she's going to have to apply for probate. The thought of that scares and intimidates her, as many of us. Marie met with our Park Memorial Aftercare team. They helped her complete the forms that Service Canada requires, and they set her up with her Cadence account to make that executor process a little bit lighter and much more timely. After answering some questions and getting Cadence up and running, Marie actually feels much more confident about getting the process underway. She reached out to a few estate lawyers for consultations, and after selecting the lawyer that she feels most comfortable with, Marie was surprised to find out that probate was not going to take several months as she had originally been told by friends and family. And she also came to realize that probate, as it involves a series of legal checks and balances, it protects her as the executor, it protects the beneficiaries, and most importantly, it actually protects Mom's estate. What she thought was going to be a nightmare actually proved to be a very helpful and positive process. This is something we don't hear very often when we hear stories about probate.
This is so true, Christy. So many people have fears and misconceptions around probate. In my experience, a lot of folks don't even really know what probate actually means. So I'm glad we're having this conversation. Megan, can you enlighten us as to what probate actually means?
Sure. Think of probate as the court officially saying, yes, this is the valid will and the right person to handle the estate. The process for applying for probate is intended to give transparency and helps ensure that the estate gets handled properly. So it involves sharing information about the deceased, their family, and their assets with the court, demonstrating that other requirements have been met, such as notifying beneficiaries and people who may have claims against the estate, providing relevant documents, primarily the will and the death certificate. The end result is called the grant of probate, which is the official court document that the executor can show as proof of their authority. They can take it to banks, to land titles, etc.
In our discovery meeting, when we were talking about probate and you shared this information with us, I remember my aha moment. I had always thought that probate was the actual process of managing the estate. But really, as you explained, it's the court's confirmation to do so. Am I correct on that?
That's exactly it.
I remember your aha moment. It really reiterates why we're having this conversation, and just to understand and acknowledge the gap that's out there. We've seen estates where they require probate and others that don't. So when it comes to ones that do or don't, how do we actually know whether we do require probate or not?
That's right. Not every estate needs probate. If all the assets were jointly owned between spouses, or if they include things like insurance policies or registered accounts like RRSPs, tax-free savings accounts with named beneficiaries, you may be able to skip probate. But if there's real estate involved, or if a bank won't release funds without a grant, that's when probate becomes necessary.
So let me understand, if an estate is small-ish, let's say financially, and the financial institution, the bank, is okay letting the executor proceed without a grant, then probate isn't required?
Exactly, though it can still be helpful in some circumstances, and the executor still has requirements to follow when administering the estate, even without probate.
So in our first discussion, we talked about when someone passes away without a will, not even a surviving spouse or partner has the authority to deal with the estate or estate assets. Often meeting with families, telling them that if someone passed away without a will, they're going to need grant of administration, and it may be required to deal with their estate. Megan, can you talk about what a grant of administration is and how it relates to probate?
Sure, think of administration like probate when there is no will. The process of applying is very similar, giving the court information and showing that the appropriate people have been notified. The main difference is who has the right to apply. When there is a will, the executor appointed in the will applies for a grant of probate. When there is no will, legislation determines who has priority to apply for administration. The grant of administration is the end result of this process and gives the person who applied legal authority to deal with the estate.
So then once that process is done and they've got the paperwork saying that they have grant of administration, then they need to apply for probate. Am I correct on that?
I do sometimes get asked this. No, it is a one or the other thing.
Okay.
I know when we are making arrangements on the funeral side of things, we have to determine who has the authority to make those decisions. So whether there's an executor or who is the person that is going to be caring for the estate. And a lot of times we don't or haven't determined what that probate process is until I go in for an aftercare meeting. And it's generally that meeting that will help determine what their next steps are going to be. Can you kind of share as to when I maybe should be stating to families the appropriate time frame when they should start to look into probate, or if they need grants of administration?
Thankfully, it's not necessary to start the process immediately after someone has passed away. At the same time, it's also important not to wait too long. I generally tell my clients to focus on being there with their families and only taking the necessary steps to protect the estate, making sure the home and the vehicles are secure, for example, and then to get in touch with me about starting the application after the funeral has taken place.
I know that our profession definitely sees the value in using those first few days to catch your breath and make plans to honor your loved one's life, to hold that funeral or celebration of life, as there is great importance on ceremony and having family gather to love and support one another through the grief and mourning process. It also allows us to start grieving in a healthy way when we take that pause to celebrate that life or honor that life, honor that person that we loved before we start to think about settling an estate and everything that goes along with it. Sarah, you and I have chatted frequently that you often have families that are trying to cram arrangements, funeral, and aftercare even into those 3 days of bereavement leave that are so precious for that process of just taking the time to be present and honor your loved one. How do you respond in your role to that, and what have you observed in those circumstances?
I mean, first and foremost, we really want to encourage families to use their bereavement time for its intended purpose. This time takes care of them for themselves, to ensure that they're staying hydrated and eating and getting some rest. We all know far too often that it's very difficult to get good rest and sleep after we've lost a loved one. So that is one of the first things that I validate with a family, is to make sure that they're taking care of themselves and for sure each other. And then taking those steps to do the necessary things leading up to a service as well. That's what that bereavement time is intended for. There's plenty of time after the funeral, essentially to look after and gather the things that are needed when you're looking towards probate or administration processes. And essentially, that's one of the big discussions going into aftercare, is that starting that process. So sitting down in that meeting with a family and being able to determine what their next steps are is huge. And it needs to be important to the family to take care of themselves, their loved ones, be reassured that during their aftercare meeting, that's when you'll be able to start that process to be able to know what your next steps are.
So then, with both of those things in mind, the taking the time to honor a life, and then taking the time to gather everything, is it fair, Megan, that starting within a week or two after the funeral would somewhat be ideal?
That would be excellent. There's not one right or perfect way to do any of this. And I have seen people who, like you've talked about, when they try to cram everything into that bereavement leave and do it all at once, I see my side of the process frequently stall out. So it can be very helpful just to take one step at a time.
That really aligns with what I see in aftercare. We need to consider the legalities up front, confirming the person who we're meeting with and actually the authority who's making the funeral arrangements. And because there's so many extended appointments that will or will they not need probate or applying for grants of administration. So when we talk about this, what I'm hearing is that although families may not apply as immediately as the first step, things still need to be processed and have that impact right from the start.
That's a good way to put it. The documents that are in place and the knowledge the executor has about the assets in the estate have a huge impact on how the administration process goes. If an executor knows that they're appointed, rather than it being a surprise, and knows what the estate assets are and where to find them, who are the insurers, what banks were used, it is far more likely that the process will go smoothly. To contrast this, I've seen situations where the executor didn't know they were appointed until the will was found after a search through the home. Then there was a further search to find out where the deceased did their banking, what debts they had, what insurance policies were out there. And this understandably makes it a much tougher job.
So now that we understand what probate and administration actually are, can we discuss the steps involved in both processes? So You've talked about, the gathering information and documents needed, that's similar. But what goes beyond that with the process of both of those things?
Whether you're dealing with a will, so probate, or without a will, administration, the steps that you follow generally include gathering information and documents needed to prepare the application. This includes the original will, if we're applying for probate, as well as the death certificate. There also may be other relevant documents depending on the circumstances. The next step is to prepare and submit the application and serve the beneficiaries and people who may have claims against the estate. When a lawyer in Alberta applies, this happens through the court's relatively new online portal, which we are able to now use for most applications. If you are not working with a lawyer, there are forms available on the government website that you would fill out and submit to the court clerk. And I know, Sarah, you've mentioned you hear this is frequently done in person when you hear people working without the assistance of a lawyer.
Yes, absolutely. That is the most common.
So once that takes place, the court clerk and then the judge will review the application, and they may ask for changes or seek clarification before the grant is issued. And then once the judge is satisfied with the application, they will issue the grant of probate or administration. This used to be a paper document signed by the judge, but now we frequently receive it electronically and forward it to our client.
So traditionally, probate has taken a long time, generally several months on average. You mentioned in our discovery meeting, Megan, that there have been big changes in Alberta, that portal, that affect the timing of probate in a very positive way. Can you tell us about that?
Sure. The process that we've been talking about has been significantly modernized, with the biggest changes happening in 2022. So since then, we've seen court forms have been simplified and are now in plain language format. The court's online portal that I've mentioned was launched, which allows lawyers to submit applications online, and that has made a huge difference. We generally receive grants within 1 to 3 weeks from applying, and we once received a grant within 3 days.
Wow.
There is still the odd challenging situation where we haven't been able to use the online system, but we are able to use it the majority of the time.
Okay, so that information leads to kind of the burning question. Do I need a lawyer in order to apply for probate or administration? And if the answer is no, can you kind of speak to the value of working with a lawyer through the probate process versus walking the road by myself and doing all of the forms and everything on my own?
For sure. So it is not mandatory to hire a lawyer, but it can certainly be helpful. When you work with a lawyer in applying for probate or administration and administering the estate, you have someone with knowledge of the rules and processes who can guide you through them. This saves time in a few ways. You don't need to spend time learning the processes and fully understanding the requirements, what forms you need, who you have to serve, what you even serve them with, who the potential claimants are. You have a greater likelihood of getting the grant without needing to resubmit because you have someone experienced preparing it on your behalf. Also, when you hire a lawyer, you are able to apply through the online portal instead of submitting the paper application, which we have found has really been a game changer for our clients. Having the knowledge and advice also protects the executor from liability. So like we spoke about last session, the executor must do their job properly and can be personally liable if they do not. And ignorance of the rules is not an excuse. So working with the guidance of a lawyer can help you understand the rules and follow them.
So you're talking about, serving beneficiaries, serving potential creditors or potential claimants against the estate. I know I wouldn't even know where to start, like how to serve a beneficiary, who to serve. I can definitely appreciate how working with a lawyer would definitely be helpful with all of that, in addition to all of the paperwork and forms and knowledge, like you said, that I don't have to have because I've got that person who has everything that I need.
I mean, all too often people start off with what I like to refer to as Dr. Google. We think we have something going on and we jump online and we start to do all of our research and get all the information we can. And sometimes helpful is hurtful. We can actually derail a little bit. Every professional has a niche for a reason.
In our discovery meeting, we talked about the importance of receiving advice, specifically when administering a farm estate. And having been raised on a farm, this caught my interest. And you spoke that there are several circumstances, like administering a farm, where it can be particularly helpful to work with a lawyer. Can you talk about that a bit?
These would be the estates that are more complicated, meaning there can be a greater risk of the executor missing something that could have an impact. So some examples are farm estates, like you mentioned. There are specific rules and timelines that apply to the transfer of farmland, making it important to deal with these estates in a timely manner. If this is not done, there can be very significant tax consequences. Another one would be estates with businesses or partnerships involved. That can significantly complicate things. Large estates or estates with significant real estate, and insolvent estates, meaning there are more debts than assets because there are specific rules that apply to those. And lastly, estates where there is a risk of litigation, either because of mistrust among the parties, disputes brewing over specific issues, or potentially claims coming against the estate.
So you mentioned insolvent estates being tricky. Can you share what happens when there are more debts than assets, and what the risks are to the executor if they don't deal with them properly? I would imagine that would be a very stressful situation to be in.
Yes, definitely. When an estate is insolvent, there are rules about which debts get paid first, so which have priority. Certain debts must be paid in full, while others, because of a lack of funds, may only partially be paid. And remember, like we talked about, if an executor makes incorrect payments, they can be liable to make up for those improper payments out of their own pockets. Because insolvent estates can be particularly difficult, it can be important for the executor to consider whether they want to take on the role, and that needs to be done before they begin dealing with the estate.
So probate has a reputation for being something negative that we always want to avoid at all costs. Is that true?
My perspective on this is no. While there are things to consider, such as legal and court fees and the time and effort needed to satisfy court requirements, the probate process can have important benefits. One of the biggest practical benefits, and I see it all the time, is the transparency that the process creates. And it can go a long way toward addressing mistrust and avoiding disputes. The other significant advantage is legal protection it provides for the executor.
You spoke very passionately about the transparency that comes with probate during our discovery meeting, and the steps that follow. Can you tell us about that a bit?
When I talk to my clients about this, I explain that Each of the beneficiaries gets to see a copy of the application. So they get to see the will, as well as a detailed list of the assets and the liabilities of the estate. When everyone is starting with the same information, it can go a long way to addressing mistrust that sometimes just exists. Later in the process of administering the estate, the executor is required to show, down to the last penny, all the assets of the estate, payments in and out of the estate, such as debts, expenses, and what they plan to distribute to each of the beneficiaries. Then, each beneficiary signs a court form releasing the executor from liability before they receive any of the funds. I discussed this with a client just the other day. She was experiencing a lot of stress about how the estate administration process would go because of family dynamics. And she literally cried out of relief when I explained these steps, because she saw how this could both improve family dynamics and also just protect her.
How does probate protect the executor from liability?
First, it limits the time available for dependents to make claims against the estate. So from the date that probate is granted, potential claimants have 6 months to file their claims. If they fail to do so in this time frame, their claims are limited only to the portion of the estate that hasn't yet been paid out. This is why we often hear about executors waiting at least 6 months, and there are other reasons to wait even longer, before distributing the assets of the estate. In addition, the process I described of providing information and requiring signed releases before paying out funds also gives executors certainty before taking a step that cannot be undone.
So while there are benefits to probate and administration, there are circumstances where we still might need to avoid them.
Yes, and we might even try to or prefer to. The main one would be between spouses and partners. When the first person in the couple passes away, there can be an advantage to avoiding probate at that time. As we've talked about, this can happen when all the assets are owned jointly by the couple or pass by beneficiary designation. Then probate is more likely to be required and have more advantages when the second person passes away and the estate is potentially passing to the second generation or to the next generation.
So then, in the case of the passing of the second spouse, or the formerly surviving spouse, if you will, could the strategy of transferring their estate by joint ownership or beneficiary designation be used to pass the estate on to children?
So first, I'll say that in the case of young children who can't legally hold assets anyway, this strategy is generally not an option. In the case of adult children, it's very important to know that the rules around joint ownership between a parent and an adult child are very different than between spouses or partners. Adult children are presumed to hold estate assets in trust for the estate rather than receiving them outright as a result of joint ownership with the parent. That is, unless a contrary intention is demonstrated. So it would have to be made clear, usually in writing, that the parent intended the child to inherit if they wanted to go that route.
I hear these ideas tossed around a lot of times with aftercare meetings, and while these ideas sound appealing, should people actually be considering this as their approach?
I appreciate the appeal as well, because at least superficially, they do seem clean and simple. But it's very important to realize that steps that may seem straightforward can actually create many unintended consequences. First, when property is transferred by joint ownership, we can't create the same contingencies built into most wills, at least not without some more complex tools being involved. For instance, if you hold property jointly with a child and then they die unexpectedly, they don't have a share now to pass to their beneficiaries. So if it's not done carefully, this could result in a branch of the family being cut out of your estate unintentionally. Second, adding someone to title to your property can create tax consequences. In Canada, this kind of transfer is usually treated as a sale of parts of the property, which can trigger capital gains unless there's an exemption. It can also reduce your principal residence exemption, which is what normally shelters your home from capital gains tax. Last, even the optics of this sort of joint ownership planning can create family conflict. I often hear some siblings may have a sense that one is being privileged over the others. This can be especially challenging if parents' intentions haven't been clearly documented or discussed with the family. It can be important to get legal and accounting advice to fully understand the implications of making this kind of transfer into joint ownership.
So some people I meet with when discussing gifts of their assets during a lifetime, what might you tell someone if they were thinking to do in doing so?
I do really caution people who are thinking about this. And I tell them that if they are wanting to transfer assets to adult children, for example, while they are alive, for some of the same reasons, it seems simpler, it avoids processes. They need to be mindful that if they do so, their assets are no longer legally available to them for their care if needed. In other words, should something change with their health, or if they live for a very long time and need those assets, this can create real challenges.
Well, I can definitely attest to the need to seek legal advice before making any of these decisions. I went through this thought process myself when we first started planning for these sessions, because I was the only one on title on my home at the time. And I considered putting my adult son on title as a joint owner of my home to make it easier for my children when I pass away. However, now I understand that had I put my son on title, he would have been deemed to have been a homeowner already and would have been unable to use his first-time home buyers to purchase his own home at some point.
That's a really good example of the type of surprise that can happen when we try to work around established processes. There is so much nuance here, and your comment really highlights the importance of proceeding in an informed way.
With all the discussions and collaboration during these sessions, it has really highlighted the human side of working with you, Megan. Lawyers often are seen as unfeeling or rigid professionals who are just focused on essentially following the rules, is kind of how it's been taken. However, you've often talked about the relationships and honoring the wishes of the person who's passed away and creating those most positive possible experiences for those circumstances.
Thank you for highlighting that. While the core of my job is to provide legal advice, it is my sincere goal to assist the people that I'm working with on a human level as well. So this may just involve listening, offering support when it's appropriate, thinking about the different relationship dynamics involved, and like you said, honoring wishes, which are all important over and above the legal considerations.
I know that Sarah and I can completely understand that. As funeral professionals, we are often of a similar reputation of being stoic and reserved and unfeeling. And the fact is, we are human first, and our commitment to engaging from that very human standpoint allows our team to far better serve bereaved families with that highest of care and compassion. I think these last reflections have brought us to a perfect place to delve into our Q&A if you're ready. Perfect. Our first question comes from Jill. Jill has a very common question. What should I think about before adding one of my adult children on my bank account?
Jill, first, you should be clear on your intention for adding them. Is it just to help with day-to-day banking, or for them to be a true joint owner, which would entitle them to use the funds for their own benefit, and even go to the extreme of transferring all the funds out of the account? If the intention is for them to be on the account for administrative ease, for example, to help with banking if something was to happen to you, this could be achieved with a power of attorney and a will. If the intention is for them to be a true joint owner who can benefit from what's in the account and would ultimately inherit the contents of the account, this should be properly documented. And then it's also important to potentially receive advice to consider whether there are any of the unintended consequences that we've already discussed.
Perfect.
So we also have a question from Tanis. If I would like to have a legal assistance as an executor dealing with an estate, am I obligated to deal with or work with the lawyer who drew up the will, or may I choose someone of my own capacity?
This is definitely a common idea that is out there, but there is no obligation for the executor to hire the lawyer who drafted the will. It is entirely the executor's choice whether to hire a lawyer or other professional advisors and who to hire.
Good to know.
One more question from Kathy. She asks, when an executor hires an advisor such as a lawyer or an accountant, how are the fees paid?
Generally speaking, the estate covers professional fees incurred in the course of administering the estate. The executor does not need to pay them out of pocket.
Todd wants to know what happens in the case where almost everything is held jointly or passes by beneficiary designation, but there are a few assets solely in the name of the person who passed, and probate is only needed to transfer one of them, such as a piece of real estate. Is it possible that probate just one asset?
No, when probate is required, it always applies to the estate as a whole. It's not possible to just probate a single problematic asset unless that asset is the only thing in the estate.
So my friend Karen is the executor for her mom's estate. Her dad sadly passed away about 6 years ago now. And so she's without a parent to guide and support her through the process. And the combination of her grief and pain at now having lost her second parent, her mom, and they were very close, along with her paralytic fear about probate and all of the processes and all of the things she has to do, has kind of led her to sit on the back burner. And now there are significant delays in caring for her mom's estate. And the other beneficiaries, which are her siblings, are now pressuring her to take action. This is also multiplying her fear that's already there. What would be your advice to someone who's in Karen's situation?
The first thing I would say, Karen, is this is truly a common situation. And it is very easy to become overwhelmed with everything that needs to be done in the course of administering an estate. The most important thing at this point is to get started. gathering information, finding out what steps you need to take, and doing so in an informed way, because it is a serious role and does have liability that comes with it. If you are unsure where to start, getting legal advice may be a great first step, as you'll have someone to guide you through the process and avoid potential missteps, which sounds like where the fear and overwhelm may be coming from.
Well, once again, I can honestly say that my own knowledge banks have been filled and refreshed through the process of preparing for and holding these conversations with you ladies. Thank you both for, again, such an informative and thoughtful conversation. I think everyone who joined us this evening has definitely gotten some gold nuggets to take away and maybe challenge their thinking, especially around probate. While our hope is that these conversations are deeply empowering, I also can appreciate how heavy they can be, particularly if you are in the process of having to administer somebody's estate or support somebody who is administering somebody's estate after the loss of a loved one. Grief makes everything that much heavier. I would be remiss if I didn't remind you that Park Memorial, in addition to these events about wills and estates, does offer a wide range of grief support events as well that will endeavor to support you through your grieving process. And all of those events can be found on our website at www.parkmemorial.com. I hope that the more we learn through these events, the more confidently we can make decisions that protect the people that we love and make things a little easier for them down the road as well. I hope that we are all challenged to take some initiative and make some decisions if we need and haven't looked after things to the best of our capacity yet, whether that's updating a will or reviewing executor choices or simply just starting the conversation with your family and your loved ones. And again, if something in tonight's discussion brings any questions in the coming days, as you process what you've heard and learned this evening, by all means, feel free to reach out to us at Park Memorial and to Megan and her team at Willwise to get the answers to those questions. That's really important as well. And on behalf of Park Memorial and Willwise, thank you for joining us this evening, and we hope you will join us again.
Hi, I'm Kirsty Smolik, third-generation president of Park Memorial Funeral Home, which my grandparents started in 1941. Thank you so much for joining us today for the third in our series on wills and estates. We really appreciate you joining us. Park Memorial is so proud to be part of our community, whether it's educating you or supporting you in your grief. If you have any other ideas in which we can help, please do let us know. Thank you again. Goodbye.